So, good morning, everyone. My name's Stuart Lloyd, and I'm a Senior Associate in Mills & Reeve's Insurance Disputes Practice. Today, we're going to be talking about illegality. We will start by looking at some general principles. We'll then take a hop, skip, and a jump through legal contracts and losses caused by an insured's unlawful act. And then we'll discuss some topical issues around the insurability of fines and ransoms. We only have 15 minutes today, so it's going to be something of a whistle-stop tour. Please feel free to drop me an email if you would like to discuss any of the areas in more detail. So, general principles. What do we mean when we talk about illegality? Well, what we're talking about in this context is the circumstances in which a court will refuse to enforce an otherwise valid claim because it is tainted by illegality. This is known as the doctrine of illegality or the illegality defence. The principle is expressed in the Latin phrase ex turpe causa non aritor actient, with apologies to my second year Latin teacher, which roughly means from a wicked act, no action will lie. In an insurance context, this is reflected in the two rules which we will be looking at today. Firstly, that a claim is unenforceable when the grant of relief to the claimant would enable him to benefit from his own criminal conduct. Secondly, that a claim is unenforceable when the claimant either has to found his claim on an illegal contract or plead to its illegality in order to support the claim. Judges, academics, and litigants have grappled with this concept for over 200 years because fundamentally it's concerned with public policy rather than doing justice between the parties. Prior to a 2016 Supreme Court decision in Patel and Mirza, the position was that once a court was satisfied that either or other of these two rules applied, it had no discretion whether or not to apply it, depending on the nature of the illegality itself. And as we will see, this had the potential to create really unfair or absurd results. So, Patel and Mirza, let me take you through the facts. Mr. Patel and Mr. Mirza entered into an agreement whereby Mr. Patel paid £620,000 to Mr. Mirza for the purposes of spread betting on the price of Royal Bank of Scotland shares, in conduct amounting to a conspiracy to commit an offence of insider dealing. They intended to use insider information which Mr. Mirza expected to obtain prior to a government announcement affecting the RBS share price. In the event the announcement never took place, Mr. Mirza, despite requests from Mr. Patel to do so, never repaid the money. So Mr. Patel issued proceedings against Mr. Mirza for recovery of the £620,000, and his claim included an action for unjust enrichment. In order to succeed, Mr. Patel would have to rely on his own illegal act, i.e. the conspiracy, and following a previous House of Lords decision, Tinsley and Milligan, his claim on illegality would fail on that basis. The unfairness in such an outcome is fairly obvious. Mr. Mirza was a co-conspirator who stood in those situations to make a windfall of £620,000. Mr. Patel, on the other hand, wasn't seeking to profit from his illegality, he simply wanted his money back. The case was litigated and made its way through the court system to the Supreme Court, where it was argued that the previous decision, Tinsley and Milligan, had been wrongly decided. The Patel and Mirza judgment is a really interesting judgment from the Supreme Court. Not only does it chart 200 years of case law, law commission reports, and a repeated failure by successive governments to take legislative action to address what are perceived as deficiencies in the law of illegality, but also because it shows a real divergence in opinion across the 9-panel bench between those on the one hand who regard the law of illegality as calling for the application of clear rules and therefore certain outcomes, and those on the other who prefer to address the equities of each case as it arises. And it's clear when you read the judgment that there's a real strength and depth of feeling on both sides of the argument, with the Lord Justices attacking, albeit in very polite and respectful terms, each of the judgment, and it is interesting to read. And the majority favoured the latter approach. It is now settled law that the court's approach to illegality is to consider whether allowing the claim would be contrary to the public interest. That question is to be judged in light of a trio of factors, namely A, the purpose of the prohibition that was transgressed, B, any other public policies, and C, the need for proportionality. And we've already seen a number of first instance decisions where judges have tried to grapple with this approach. So going back to our ex terpi causa principles and dealing with the second first, and the question of illegal contracts. A contract can be illegal in its inception or in its performance. A contract is illegal in its inception when it is made to achieve or further an objective which is unlawful or contrary to public policy, or where the contract is prohibited by law. So, a contract of insurance will be illegal if it amounts to a contract to commit an illegal act, or it seeks to reward an insured for doing so. A contract is also illegal from inception if it was made by insurers without authority, for example, by breach of the Financial Services and Markets Act 2000. A contract is illegal as performed where it is performed by a claimant in an illegal manner, or where a claimant intends to do so from the outset. Looking then at the second of our principles, and losses caused by an insured's unlawful act. It is a statement of the law that illegality will also defeat a claim where the insured has intentionally brought about a loss under the policy by an act which is itself unlawful. And within this statement, there are in fact two rules of law which would bar a claim in such circumstances. The first is not a matter of public policy, but is a rule of construction that it is presumed that a policy was not intended to cover losses which have been intentionally brought about. This really stems from first principles, given that the fundamental purpose of a contract of insurance is to protect against the occurrence of uncertain risks. By definition, an intentional act is not uncertain, and absent clear wording will be presumed not to be covered, whether or not it's been expressly excluded by the policy terms. The second rule is an application of the ex terpi causa principle, that the court will not allow a party to recover a profit from or an indemnity for his deliberate crime. So a man who insures the life of another cannot recover if he murders that person. Equally, a murderer cannot take any benefit under the will of his victim. The rule will also apply in some circumstances where there's been an intentional crime but an unintended loss. The loss is said to have been caused by the criminal act of the insured if it was the natural or probable result of that act, and so was clearly risked by the insured. Now, there have been a series of cases which have addressed the ex terpi causa principle in the context of joint criminal enterprise. In Delaney and Piggott, the fact that the claimant passenger and defendant car driver were in possession of cannabis with intent to supply was found not to have been the cause of the claimant's injuries when there was a serious accident caused by the defendant's negligence. In that case, the criminal act was found to be merely incidental to and not connected with the loss. In contrast, in the case of Joyce and O'Brien, Mr. Joyce was holding onto the back of Mr. O'Brien's van. Mr. Joyce, somewhat predictably, fell from the back of the van, and Mr. O'Brien pleaded guilty to the offence of dangerous driving. In time, Mr. Joyce brought proceedings against Mr. O'Brien for the injuries he sustained. Mr. O'Brien's insurers defended that claim on the basis that both men were at the time involved in joint criminal enterprise. They had stolen ladders and were seeking to flee from the scene of the crime. The Court of Appeal upheld the first instance decision that Mr. Joyce was not entitled to recover damages, as the injury occurred as the result of his criminal conduct, and that conduct was as causative of his injury as that of the driver. And it's also against public policy that a punishment for a crime be indemnifiable. This is because it's against public policy that a punishment imposed on an offender, partly or wholly as a deterrent against further offences, whether in relation to that individual or society as a whole, should be shifted onto the shoulders of another. And insurance against such a loss would be unenforceable or void. This was considered by the Supreme Court in Les Laboratoires Serviers and Apotex, in which the Supreme Court considered the question of what acts constitute turpitude. This obviously includes criminal acts, but it also includes acts that are quasi-criminal because they engage the public interest in some way. This includes dishonesty and corruption, prostitution, infringement of statutory rules enacted for the protection of public interest, and which attract sanctions of a penal character. Lord Sumption, giving the leading judgment, went on to say that torts, breaches of contract, statutory and other civil wrongs offend against interests which are essentially private, not public, and therefore there's no reason for the case law to withhold its ordinary remedies. This brings us on to the question of the insurability of fines. And the first point of call is always the policy language. And you'll often find that fines will be excluded, but there are some policies, including often cyber liability policies, which will seek to provide cover for fines to the extent that they are insurable by law. In that case, what's the position? Well, in my view, it's necessary to look at the nature of the insured's conduct. And in broad terms, there are three categories of conduct. There could be intentional or reckless wrongdoing, strict liability situations, or negligence. In broad terms, where a fine results from intentional wrongdoing, it is, in my view, unlikely to be indemnifiable. Strict liability fines, on the other hand, may well be indemnifiable, provided there is no requirement that the insured's conduct involves an element of moral turpitude. Fines imposed for negligent conduct are perhaps more complicated, and in theory, civil fines or penalties for purely negligent conduct should, in theory, be insurable. The question is really the degree of moral turpitude involved in the conduct itself, which, bringing us back to the Patel and Mirza guidelines, leaves the question wide open for argument. So we're going to finish today with a look at the question of the insurability of ransoms. And until recently, the payment of ransoms has not been expressly prohibited. This was considered in detail and confirmed by the Court of Appeal in the case of Macefield AG and Amlin Corporate Member Limited. That case concerned the hijacking of a vessel off the coast of Somalia by pirates. The judgment considered the previous authorities, industry practice, and government policy, and commented that the waters were morally muddied, and that there was an unexpressed complicity between the pirates on the one hand and the world of commerce on the other, but that there was no substantially incontestable public interest which would prevent the payment of ransoms. On the question of the engagement of the Bribery Act 2010, the court also found that the payment of a ransom in response to threats to life or liberty is not, on the face of it, a bribe done for the purpose of obtaining an improper advantage. It's worth highlighting that the position is different in relation to terrorism. This is because Section 17A of the Terrorism Act makes it an offence for an insurer to make a payment under a contract in response to a demand made wholly or partly for the purposes of terrorism, and where the insurer knows or has reasonable cause to suspect that the money is to be handed over in response to such a demand. And it's important to note that the liability for that defence is with both the corporate entity itself and a director, manager, secretary, or other senior officer who consent to such payment or allow it by neglect. Well, that brings us to an end of the sessions now until September. We'd love to hear any comments or suggestions that you may have about topics for the future. Otherwise, we will be leaving the session open for a little while now for you to continue posting your feedback. We will, however, stop recording.